Okay, now proceed.
I would reserve 6 minutes.
We usually don't allow more than 5, otherwise it
I
kind
would
of flips.
reserve 5 minutes.
That'll be fine. That's one of those our unwritten rules everybody's supposed to know.
And that's one I didn't know. I apologize.
5 minutes will be fine.
May it please the court, I'm Dale Montpelier. I represent the plaintiff appellants, Brett and Cerie Houghton, who are sitting here behind me, along with my co-counsel, Catherine Young. Now, your honors have read the briefs, and you know that the Houghtons are a couple who owned a Malibu boat dealership, which is now a defunct business. And Malibu is a publicly traded multinational corporation. After 5 years of litigation and a 1-week trial, the jury awarded them $900,000. After the post-trial motion deadline passed, the defendant raised an argument of subject matter jurisdiction. Judge Pemberton vacated the judgment, and we're asking that it be reinstated. The appeal deals with one issue of law, which of course is reviewed de novo. Now, the jury found 3 types of fraud: intentional misrepresentation, fraudulent concealment, and promissory fraud. That fraud destroyed the Houghtons' business, and it destroyed their lives. The jury wanted the Houghtons to have a recovery, and they selected one category of damages on the jury verdict form. The defendant wants that jury verdict to go away. A triple finding of fraud by defendant's highest executives hurts its dealership sales model. The problem is the defendant failed to timely raise their new defense of standing. So how can it possibly maneuver a way to make the verdict go away? The only defense that can really never be waived is subject matter jurisdiction. So after all is said and done, the defendant claims about a damage category. So that brings us to the 2 types of standing. The first is jurisdictional, statutory standing, and it cannot be waived. The other is not jurisdictional, it's judicial standing, and it can be waived. And the Supreme Court in the Hargett case, they stated the rule succinctly: the issue of standing cannot be waived when a statute designates who may bring a cause of action. Here, the Houghtons brought individual fraud claims, purely individual. Now, 5 years after litigation and a 1-week trial, after the JNOV deadline passed, the defendant says that category of damages had to have been brought derivatively. And so it comes down to one simple question: is there a statute that makes statutory standing applicable? That's the only issue before the court. But where is that statute that specifies the sole designated persons who can seek that category of damages related to a corporation? That would be statutory standing. But there is no statute, none. The trial court relied on the Supreme Court Keller case to determine who can recover damages related to a corporation. But the Keller court did not reference a statute because none exists. The Supreme Court relied on Delaware case law and adopted a Delaware case and reviewed treatises. That means the Keller case has nothing to do with statutory standing. Now, to further drive that point home, there's 2 important quotes from the Keller court. It says, in most circumstances, the proper party to bring a claim on behalf of a corporation is the corporation itself. And they also say, finally, the buyers urge this court to make an exception to the general rule prohibiting a shareholder from asserting a claim belonging to the corporation. We recognize that some courts are inclined to treat claims against closely held corporations as direct in nature under some circumstances. However, we are not inclined to do so in this case. In this case, general rule, in most circumstances, if this were statutory standing, there would be no exceptions at all. This is a case of non-jurisdictional standing, and the defendant waived that argument. It wasn't in their answer. It wasn't in any of their motions to dismiss. They failed to raise it during their motion for a directed verdict. They even approved the jury verdict form with that category of damages. And then it was in none of their post-trial papers.
And the damages, correct me if I'm wrong, but the damages that the jury awarded were related to the building that the corporation owned.
Yes. Yes, they were. And it may have been a valid defense. But they didn't
That's my
raise it.
question, is do you agree that absent the waiver, their argument is correct, that your clients cannot recover damages that are actually owed to a corporation?
Perhaps because the Keller case said there's exceptions. We don't know if this case is an exception. General rule in most circumstances, yes. In this case, we don't know because they waived the argument.
Because I think one of the broader concerns is the fact that your individual clients had to file bankruptcy.
Yes.
And we have a potential asset that's not listed, that being the $900,000 that actually may belong to the corporation. Did the corporation list it as an asset? I mean, the fear is there's this windfall of money that maybe should have gone to creditors in bankruptcy that now is not collectible, that just goes straight to your folks.
Your Honor, I would respectfully disagree. The cause of action, this cause of action was listed on the bankruptcy papers. It's of record. They had the bankruptcy case reopened, making that argument, and the chief bankruptcy judge rejected it. Plus, it's not an issue on appeal. As for the waiver, the trial judge specifically found if non-jurisdictional standing applies, they waived it, and they did not appeal that decision. I mean, it's just simply not before the court. The only question is whether there's a statute. There is no statute. So, respectfully, and we have the greatest respect for Judge Pemberton. He did an excellent job in this trial. But he's an heir. The verdict should be reinstated. It's the right thing to do. It's the legal thing to do. The Houghtons deserve that $900,000. The jury said so. And the words of the jury should have meaning. I'm happy to answer any other questions.
I hear none.
Thank you for your time.
You have your time for rebuttal. We'll hear from the appellee.
Good afternoon. Taylor Williams, Payne Bickers, on behalf of appellee Malibu Boats LLC. On the papers also is Mike and Kyle Baisley, although they're not here today. We heard a little bit there at the end about what is right and what is wrong.
Sorry, I'm going to do this to you again. Pause it a second. I meant to tell y'all before, his law firm, once upon a time, 25 years ago, was my law firm, just as it was Justice Tarwater's law firm. I have had nothing to do with it and sadly received no money since then or anything like that. But I just wanted to make sure that you all were apprised of that. And there may only be one lawyer left there that I even know. But I mean, I should have brought it up before, but I forgot. I want to apprise you now. And if you have any problems with it, tell me now. I kind of hate to do it now, but.
Your Honor, after your dissent in the lawsuit between me and Mr. Monsieur, your integrity is impeccable.
All right, thank you. Proceed now. I'm sorry.
Absolutely. And so we heard some discussion about what is right and what is wrong, and it seemed like there at the end we diverted onto what is right or wrong in a moralistic sense, and that certainly has its place, but we didn't hear a lot about what is right and wrong in a legal sense. And I believe from a legal standpoint, what we heard was one argument, as Judge Davis pointed out, that is waiver. That's the only argument that's being made. And as I was taught, there's really two ways to make an argument. One is to say why your side's right, and the other way is to say the way the other side is wrong. And if you can't really say why your side's right, then just wholly relying upon why the other side's wrong typically doesn't get you where you need to be. So I want to explain why Malibu's side is legally correct. Everyone knows, including this panel, that corporations are separate and distinct entities. In fact, they were infamously given the same rights as people at one point in time. But corporations have certain rights, they have certain responsibilities. The shareholders of those corporations have to do certain things like file annual reports. They have to maintain corporate separateness, not commingle assets. And if they have to, or if they do all these things, then they obtain certain benefits. Some of those benefits are tax, accounting benefits, and of course, as everybody knows, the liability shield. And again, as pointed out earlier by the court, the individuals in this case have been benefited by the corporate shield, the liability shield. The entity has $1.2 million worth of consent judgments against it. And the Houghtons enjoyed that benefit. But now, in a what appears to be kind of an odd veil piercing in reverse, the Houghtons are asking for this court to ignore the corporate formalities, to ignore the existence of the corporate entity itself, so that they can individually recover this $900,000 and that not a dime of it will go to the $1.2 million worth of consent judgments. And Judge Davis asked earlier about bankruptcy. Had been brought in the corporate name and the $900,000 had been awarded to the corporation, then 75% of those consent judgments would have been, or absent any other fees and expenses, et cetera, would have been satisfied. And this idea that corporate shells and entities can be used to the benefit and not used when it doesn't benefit the shareholders was expressly addressed by the Tennessee Supreme Court in the Keller opinion in 2016. And of course, the Keller opinion is the one that is the leading case on derivative versus direct actions. And it said, used the word caution, and it cautioned courts, when parties have deliberately undertaken to do business in corporate form for tax purposes, accounting, and other reasons, they must be held to the corporate form, and they cannot shunt aside at their convenience legal entities and the legal aspects thereof. And that is precisely what is being done here, what was attempted to be done.
I'm sorry, let me ask you
Sure.
questions here. The trial court did what it did based on lack of standing, correct?
Correct.
And that was the sole basis for it.
That is correct.
Do you agree that there is a statutory and constitutional standing, kind of one category, and for lack of a better word, court-created standing on the other?
Yes, sir.
The first two, would you agree the first two, statutory and constitutional, can't be waived?
Agreed, Your Honor.
Do you agree that the second one, what we normally think of as standing, can be waived?
In the correct circumstances, yes, Your Honor.
All right. When did your client raise lack of standing?
Okay, so
The first time?
the first time, well, I have to back into that a little bit.
Sure.
So if it is statutory standing, then it can never be waived. And the subject matter jurisdiction as subject matter jurisdiction was first raised post-trial. Okay. Constitutional standing has three aspects. And one of those three aspects, well, two aspects that are issued in constitutional standing. One is that there must be a distinct and palpable injury, and then two is that there's a causal connection between the alleged injury and the conduct. Both of those aspects were frequently challenged throughout the trial, specifically that there had been misrepresentations made to the individuals and that the harm being alleged, the causal connection, was to this loss of equity in the property. So those two issues, which go directly to constitutional standing, had been addressed on numerous occasions. I believe it's in the transcript, volume 12, around 1610, around that point. It's cited in the brief.
So is it your position then that this is constitutional standing is what was raised and not statutory standing?
We believe that it is statutory standing.
So it is statutory?
It is statutory, but actually that both are triggered. We believe both are triggered from the standpoint of, and if I can, Your Honor, let me talk about the Keller case. Okay, the Keller case said we have to determine what is derivative and what is direct. And the issue with what is derivative and what is direct is that when an individual shareholder attempts to seek damages that belong to the company, but they file it in their individual names, the two factors from the Thule test that coming out of Delaware are who was injured and to whom would the recovery flow. Okay? And if those two things don't match, then the individual shareholder does not have standing, and that would be both constitutional and statutory standing for different reasons. But that's what the Keller case does. And it's important to talk about the Keller case for a second because we are discussing the waiver. The facts in that case, standing was not raised until trial in that case. It was raised at trial. And one of the claims in the case was interference with business relationships, which is analogous to our current case because interference with business relationships deals with a corporate asset that has allegedly been injured and that the individuals attempted to recover. And what is important about that is that the Supreme Court in Keller looked at the evidence that came in at trial to go through the Thule analysis. In other words, it is appropriate to look at the evidence that comes at trial and then make a standing issue argument or raise a standing issue because it requires the factual findings that come in at trial. Could they have been addressed at summary judgment? Sure. But they don't have to be, and they can, in fact, be raised at the trial court level, which is what happened in Keller and is what happened here. And so we believe that the Keller case suggests that it is constitutional standing because what it says is that an individual cannot have a causal connection between the alleged injury and the alleged harm, and they do not have a distinct or palpable injury, which are both Article III constitutional standing issues, if they don't bring either a direct or a derivative action. Additionally, statutory standing is invoked because there is a statute on derivative actions in the state of Tennessee. And if part of the Keller analysis was to, the Tennessee Supreme Court said this, they wanted to adopt Delaware's standard in Thule because it gave the rich body of law in other jurisdictions for guidance in applying the Thule standard, i.e., Tennessee courts and Tennessee practitioners can look at the other cases that have looked at Thule and rely upon those. And there is a Sixth Circuit opinion called Prince v. Palmer, whether plaintiff that states, cited in our brief, it's 148 Federal Appendix 249, Sixth Circuit 2005, whether plaintiffs maintain standing to pursue their shareholder derivative action under the Delaware corporate statute is an issue of statutory standing. And so whether or not the Houghtons complied with the derivative action statute is statutory standing. And it is admitted in the Houghton's brief that they did not file a derivative action. So that is not an issue for dispute. They did not file.
And that's what they've said here today, that this was their personal and their individual actions for those three
misrepresentations
counts, I guess. So they weren't attempting to bring an action on behalf of the corporation, correct?
Correct. Yes, Your Honor. So it is a weird, we find ourselves in a weird position. And this is why it was not waived, is because it wasn't until the jury came back that we knew what damages were awarded.
Well, you knew the jury form that went back to the jury.
And that was objected to.
The record shows was objected to that particular.
Yes, specifically the damages related to the building. On whether or not the harm alleged, or the wrongful conduct alleged, the misrepresentations, there was evidence to support that that was linked to the injury to the building. Okay,
in that aspect, was there ever, when was the trial court, or if ever, apprised that, hey, this looks to me like this is an element of their cause of action, damages individually, an element of their cause of action, as they say their interest in the building was damaged. So they have to prove they have an interest in the building. I guess I'm having a little trouble understanding why it's standing as opposed to simply an element of their claim.
Well, I think it could be both. And it was argued that they had not shown the evidence. But again, being statutory standing, it's not waivable because it's subject matter jurisdiction. And so whether or not it was raised, at what point in time, it doesn't matter. In fact, the court could have sua sponte raised it. This court could sua sponte raise it. This is where you started to go, and I want to discuss this as well, that the category of damages is part of the Thule test. The Thule test requires that we look at essentially the claim and the category of damages. And so the fact that there may have been other things on that verdict form that were individual, and the Houghtons could have maintained direct claims. But that's not what the jury awarded, and that was not known until the verdict came back. And so as was done in the Keller case, the court looked post-trial at the evidence that came in at trial to determine whether or not it was a derivative action, i.e. it would have to comply with the derivative statute and would be statutory standing, or whether it was a direct claim for direct injuries.
All right. So is it statutory or constitutional or both?
I believe it is both, Your Honor.
You think it's both here? What statute specifically?
The derivative, Tennessee Code Annotated 4817-401, which brings the statutory requirements for bringing a derivative action. Those requirements are mirrored in Rule 2306. That you can't, it's, I put in the brief, it just ain't right. You just can't get the corporate damages as an individual unless you bring a derivative action. And they didn't bring a derivative action. And so I think perhaps what Your Honor is struggling with is they didn't even attempt to bring a derivative action. Had they attempted to bring it, it could have been challenged ahead of time. It was brought as an individual action, but the corporation damages came up at the end of the trial. And
in your motion for new trial, did you specifically raise standing in the written motion?
It was not raised in the written. It was raised at the hearing.
It was an oral argument.
That's correct, Your Honor.
Okay.
I have a question. The contract, the yearly contract, the dealership agreement between Malibu and the Houghtons who is that with? Is that with Great Wakes?
Yes, Your Honor.
It's not with the Houghtons individually?
That is correct.
But the allegation is that the false representations were made to the Houghtons individually or in their capacity as officers for Great Wakes?
That was the allegations of this complaint. Keep in mind, there was a 2015 complaint brought in the name of the corporation by the corporation for harms to the corporation. Mm-hmm. And instead of refiling that in 2018, the individuals filed. And there were some personal things involved in the lawsuit. For example, the Houghtons showed up to the boat show, and it turned out there was another dealer who had already gotten a new contract. And that obviously, there were monies that perhaps they had paid individually or the embarrassment associated with it that could have been individual claims. But that's not what the jury awarded. What the jury awarded was a corporate damage and a corporate loss. And under Keller, under the statute, an individual shareholder cannot obtain corporate damages unless they file a derivative action. And even if they do so, and this is perhaps where Your Honor started, even if they do so, they have to bring it in the name of the corporation. It is a failure of statutory standing that it was not brought in the corporation's name to recover the corporation's damages. And it may not be, I understand that the timing of the issue is a concern for this court. It may not be until the end, when we know the trial evidence that comes in and the jury verdict award, the damages that are awarded, that the issues surrounding whether it is a derivative claim or direct claim under Thule and Keller can be determined. But it is our position that ultimately the trial court got to the right level, got to the right position based upon the arguments that were made at the trial court level. And so I believe that's my time, unless there are any further questions.
I hear none. Thank you.
Thank you.
Here from the appellant rebuttal.
Respectfully, Your Honors, so much smoke has been raised, it would take a CNI dog to see through it, because this is a very simple question. There is no statute. We're not in Delaware. Whether Delaware has a statute or not, it's great for their courts. Doesn't apply to our courts. Supreme Court was pretty clear in Keller. It's a common law rule. Now, on the statute they raised, we really need to understand how things went. At the trial court, they relied exclusively on the derivative statute dealing with nonprofit corporations. That's it. The Business Corporation Act, which would otherwise be applicable, was raised after. So we would argue that that statute is a waived argument. Now let's assume it wasn't waived. That statute does not say who exclusively can claim certain damages. This is what it says, quote, "A person may not commence a proceeding in the right of a corporation unless they are a shareholder." The Houghtons didn't bring a proceeding in the right of a corporation. They brought individual claims. And the jury saw fit to award them damages for the building. And there's no statute saying the jury couldn't do it. Now, I'm astonished that we're hearing an argument today that it wasn't waived. It was absolutely waived. Standing was never brought up at that trial. Page 1259 of the transcript, Judge Pemberton, other than objections on the court's ruling on the Rule 50 motion and the jury charges, objection to the form? Mr. Ward, none. The judge, other than previously noted, myself, none. And then they approved the jury instructions. They approved it, we approved it. That's on page 1264.
They approved it. I understood counsel to say they objected to the part about the damages for the building.
No, Your Honor. They objected to whether the Houghtons proved the damages and the value of the damages. They didn't object and say they can't get these damages. Had they objected, that line wouldn't even have been on the jury verdict form.
Okay.
It's pretty unfair to say now, after the fact, after the jury ruled, oh, yeah, that shouldn't have been there. That's a day late and $1 short. Or that horse is so far out of the barn, it's in Canada. It's just unfair. It's a waived argument. And Judge Pemberton found it was a waived argument. They cannot stand here today and say it wasn't waived. There is a specific finding by the trial court that it was waived if it's non-jurisdictional standing. That's it. That's closed. They didn't raise that issue on appeal. Shouldn't even be considered. Now let's take it a step further. The Neeran case, the Supreme Court Neeran case, they say standing can only be contested one of 4 ways. A specific denial in the answer. That complaint seeks a loss of equity based on the actions of the defendant to the business. There is no specific denial in the answer. And they specifically say, not an affirmative defense, a specific denial. Second way, a Rule 12.026 motion to dismiss. They filed like 4 motions to dismiss. None of them raised that argument. A Rule 12.03 motion for judgment on the pleadings, never filed. A Rule 12.06 motion to strike, never filed. I mean, that's it. 4 ways under Neeran. They didn't do any of them. Unquestionably waived. With respect to the whole issue of the Constitution, and again, it was never raised to the trial court. That's waived. And this whole notion that the Constitution applies, using their argument, every case of standing would be jurisdictional. Well, there's an awful lot of Supreme Court case law saying that's not the case. That's just not applicable. Your Honor, Your Honors, this is a simple case. They can either point to a statute that says only the shareholders can get a certain category of damages. They haven't done it. They haven't carried their burden of showing that. No such statute exists. The one they quote, in addition to being waived at the trial court, just isn't applicable. And the judicially created non-jurisdictional standing, it's been waived 6 ways to Sunday, and it's just not an issue on appeal. And I would urge you not to get sidetracked by that argument, because it's just not an issue. Happy to answer any questions you have. Thank you for your time.
Here, and our thanks to counsel for both sides. We appreciate your oral argument and your briefs on this.